So, so Rebecca, are you in Nunavut today?
Not today.
No.
Uh, we have I'm back and forth. Santana and I are just we've just recently booked some travel back and forth, but we were thinking that we better enjoy some warm weather right now because
Now, because
it'll you
it's,
know
you know,
end of
You're in Ottawa, is
you're
that right?
yeah, I'm in Ottawa right now. Yeah. Hello, we're just getting everybody in.
Any chance we'll see you again in Winnipeg?
I was in Winnipeg last weekend for Annette Horst's birthday.
Oh,
I just
wow.
visited. Yeah, so I did get you guys have had a really hot summer, I guess, eh?
Well, it's not hot today.
Okay.
Apparently it was hot while we were away.
Okay, yeah.
I think we missed it.
I was told it was hot, but I wasn't there very long. So it
Okay.
was just nice when I was there. It was nice sunny days.
Oh,
Yeah.
good, good. Yeah, it was certainly hot in Japan. It got up to 38 while we were there, which is too hot for my liking.
Yeah.
Uh,
Ugh.
but
Yeah.
yeah.
Wow.
Uh,
Well, I think it looks like we've got everyone in. So I wanted to say just a couple words of welcome and I won't belabor it, but I'm very grateful on behalf of the Lost Site of Nunavut. I'd like to welcome Alistair Clark, who's the principal of Clark Immigration Law that is headquartered in Winnipeg, but deals obviously immigration law is national in scope. And Alistair has graciously agreed to join us just having returned from a trip to Korea and Japan and possibly other places. So it's just marvelous that we're able to have Alistair here. Thank you again for agreeing to do this. And so I will not belabor that further, and I will give you the floor, Alistair, and we can proceed.
Perfect. Thank you so much. So thank you for the warm welcome and the invitation. I love speaking about Canadian immigration law, and and hopefully some of the information provided today will be helpful in your practice or in your personal lives. Obviously, today I'm giving kind of general information. I can't provide specific legal advice on any specific cases. But if you do need a follow-up after this presentation, feel free to contact my office, and hopefully we can help. So I have divided up this presentation into kind of 10 or 11 different sections, talking about various aspects of Canadian immigration law. My understanding is that the attendees today have a pretty basic knowledge of immigration. So I'm kind of going through some of the basics, and I will be kind of making sure that you understand the basic tools, and then also diving into some particular topics. But I love questions, and so if you have any questions, please feel free to jump in at any point. If there's anything that I've said that doesn't make any sense, also just let me know. This presentation is for you guys. And so if you want to give some feedback, if I'm going too fast, just let me know. For me, I've been doing this now for more than 15 years. And so sometimes if I get into too many acronyms, I'll just apologize in advance. There are many, many acronyms in immigration. And so if there's something that I've said, just feel free to jump in. Okay. So the starting place in immigration is talking about different types of status. So this is immigration status. So from my point of view, there are approximately five different types of status. So the first one is stateless. So we regularly deal with individuals who do not have any status. This is for example, an individual who has come from a country and maybe that country no longer exists, or if they've come from a country and that country has revoked their status and they are in Canada and they have no status. The second category are foreign nationals in Canada without status. So they came to Canada with status, and then through particular circumstances, they have lost their status. So they are a citizen of a country, not in Canada, obviously, but they, for whatever reason, have decided not to leave Canada, and they have lost their status from the Canadian government, and they continue to live and work in Canada. In the United States, they consider, these individuals to be illegals and all of that. The Canadian government is not so harsh with individuals from my perspective, unless these individuals have committed a crime or they've been convicted of a crime or something along those lines. Then generally individuals in this category kind of they're able to go about their business. Often they will work for cash, they will work under the table. I had a case a couple of years ago with a woman who had been in Canada without status for more than 30 years. And we were able to apply for her so that she was able to regularize her status in Canada. The third category are individuals with temporary status. So these are international students, workers, visitors. This is the category that seems to be getting a lot of news recently. Both Minister Mark Miller and other ministers have focused on these individuals as kind of the cause of our housing problem or other types of problems. They have drastically cut the number of study permits, and they have increased the requirements for future study permits. They want to, just recently, the Quebec government has announced that it wants to completely freeze the temporary foreign worker program. Recently, earlier this year, the Canadian government imposed restrictions on Mexicans so that now they require a visitor visa, or we call it a temporary resident visa, in order to come to Canada. But these individuals right now are going through a very rough time. The federal government has announced that they want to drastically cut the number of individuals with temporary status. The fourth category are individuals with permanent resident status or PR status, the American equivalent to someone with a green card. Typically, this is the goal of many individuals who come to Canada. They want to get PR, and we help a lot of individuals on this path. There are many different types of applications to get permanent resident status. And in some cases, especially if the individual is coming from a country that does not allow dual citizenship, then once they get PR status, then that's the end of the road for them in terms of achieving their immigration goals. They don't want to become Canadian citizens because they don't want to lose the citizenship of their country of origin. And then finally, if they can get dual citizenship, then the fifth category is Canadian citizen. And so citizenship is either based on if you are born in a country, jus soli, apologize for the Latin, or if you achieve citizenship through blood or jus sanguinis. Canada is a jus soli country. It's actually a minority in the world in terms of giving citizenship by birth. But right now, the Canadian government is in the process of changing citizenship laws. Citizenship laws are quite complicated. It seems like every government that comes into power wants to kind of put their fingerprints on our citizenship laws. And so if you go to the application process, if you can go through all the different versions of the Citizenship Act and look at all the different changes. Okay. So typically in terms of where we get involved with either helping people get status, or we get involved when the government is trying to take it away. Typically, there are two departments of the federal government that are involved in these processes: IRCC, Immigration, Refugees, and Citizenship Canada, created by the Liberal government. It used to be called CIC. So they typically give status. So those are the officers around the world who give study permits and work permits and all of that. And then if an individual has an admissibility issues, or if they have worked without authorization, or they are subject to some kind of enforcement, then we're dealing with CBSA. So Canada Border Services Agency. They are in charge of removals, and they are under the Minister of Public Safety. Then you deal with individuals who are in Canada and they want to change their status from inside of Canada. So typically, when a foreign national enters Canada, they must declare their purpose. This declaration is extremely important, and it can have kind of a ripple effect on future immigration applications. So if an individual comes, for example, as a visitor, and they tell the officer at the airport or the port of entry that they are coming to Canada to visit Canada. And then a few months later, or maybe even a few days later, they then submit a work permit application or a study permit application. Then that can lead to issues. And often the officers will want to hear an explanation as to why they have changed their declared purpose. One of the questions that we often get from people who come to our office is, can I get a work permit? And, you know, the work permit situation pursuant to Regulation 186 is extremely complex. There are many, many, many different types of work permits. So, when I get this question, my brain just kind of explodes. What is your situation? What type of work permit could you qualify for? What type of work permit might help you? Why do you want the work permit? What are you planning on doing with the work permit? Do you have an offer of employment? Things like that. And so this I've just kind of put on the screen kind of part of Section 186. And then in addition to this, there are a whole bunch of public policies that also could lead to work permits. The general two categories are closed work permit. So that's a work permit that is attached to an employer, and then an open work permit where the individual can work anywhere they want. So these are some of the common work permit codes. And part of, a lot of what we do is, people go to agents, or they go to consultants, and they get help from sometimes Good Samaritans as well. And they will submit an application, and the application is not clear. And so the application may be refused. Maybe they were eligible for a work permit, but because of possibly the confusion within the application, or possibly the application was not done properly, then it's refused. And so a lot of what we do is kind of fixing situations. And so these are kind of some of the common codes that we see that are that need to be part of the application, which are sometimes not part of the application, and that can lead to refusals. So just, probably like a co-op program, that the fourth one on this list, which is a code, which is a C32 or a C33. I've seen that many times, where an individual, a student, is applying for a co-op work permit. And it's not clear from the application, and so they get a refusal. And often, they're in the middle of a co-op program, they're studying, and they need this work permit, and that can really mess up their studies. It can mess up their situation, and they don't understand why the IRCC officer refused their work permit application. So these are some of the common mistakes that we see. So number one, unfortunately, shady agents. There are so many agents out there who are doing this for the money, you could say. A big problem right now, I would say, is that there are many agents who charge $30,000, $40,000 for a closed work permit. And what happens is that they will work with a small business owner, let's say a coffee shop or a small franchise, and the applicant will pay them or pay the agent the money, and then the money, then sometimes it goes back to them in terms of wages, but of course that is against the law, and so CBSA can get involved, and employers can also be punished based on compliance issues and other problems. So unfortunately, there are many shady agents involved in immigration. It's kind of sad, but and in fact, some agents, even in Winnipeg, there was a gentleman who was Korean, and I think he went to jail. So it's pretty sad what can happen. The second point is inconsistent information. So when we take a case, often the first thing that we do is we do an access to information request in order to get a copy of the client's immigration history and to make sure that, you know, the information that we're submitting in future applications is consistent. Because when the information is populated within the system, the officer is looking for inconsistencies, and inconsistencies can lead to big issues, which is kind of a segue into the small point that sometimes small mistakes can lead to big issues. And so we sometimes get individuals who come to us and they say, oh, I just made a small mistake in my application, or I checked, I checked no when I should have checked yes. I didn't understand the question, but I didn't think it would be a problem. And so we are retained to try to fix those situations. The fourth issue is a big problem with the immigration portals. We have many different portals that we have to deal with. Sometimes individuals and representatives, I will say, what they do is they will upload documents and then they will forget to submit the documents. And that can lead to refusals. There's currently litigation going on in BC against some immigration consultants who did that, and their clients are victims of that, and it's considered to be negligence. At least that's my understanding. And there's a really good podcast if you want to listen to more details on that. It's called Borderlines. And friends of mine, Steve and Diana, they interviewed the civil litigator in BC about the work that he's doing on behalf of those clients. And so he is alleging that those consultants were negligent, and there are some pretty hefty potential damages against those individuals. So the fifth point is poor explanation. This is, again, a very common mistake that people make. When I talk to IRCC managers or other officers, what they tell me over and over again is if there's no explanation in the application, then they will make a negative assumption. So unless the individual or the applicant is putting in the explanation, then the officer cannot give them a positive determination. Six is relying on information from Facebook and social media. Unfortunately, there is a lot of misinformation and potentially even disinformation, which is circulating online. And I hear it almost every day, or at least every week, where individuals are relying on that information, and it's often out of date, or they hear about one situation and they think that maybe it applies to them or some other situation. And unfortunately, that can also lead to mistakes and issues. And then finally, wrong fees. So the IRCC fees regularly go up, and we have to make sure that you include the right fees. If it's an open work permit, for example, there's an additional fee, which is the open work permit fee. If it requires restoration, then there's an additional fee for restoration that also has to be included. And if those fees are not included, that can also lead to refusals. Okay, so this is So this is just a recent report from the United Nations talking about the Temporary Foreign Worker Program. So this is from last month. And right now, with the closed work permit system, you know, the UN has said that the current system is a breeding ground for contemporary forms of slavery. And I have to admit that I completely agree with this. I've been saying this for years. We've dealt with many of these situations where the temporary foreign worker has been subject to just completely atrocious working conditions, and they are doing it because they feel like they have no choice, and they believe that they do not have legal rights. And so these kinds of situations are particularly gut-wrenching. And sometimes when I see an individual in this type of situation, just the fact that they're in my office or they've contacted my office, that is sometimes such a difficult step that we really try to help as much as we can because they have already taken the hardest step to actually seek help. And so these individuals require particular attention, and there are many sad cases within this category. In terms of on the employer side, so increasingly the government has been increasing their investigations against employers who are non-compliant. Here are some of the employers who are in Manitoba who have been non-compliant, and this is all published information on the IRCC website. And so you can see some of the penalties that are imposed on these businesses. They can have a fine of like for example, $58,500, or bans from hiring temporary foreign workers. And a lot of these businesses don't realize that as an employer that they have to be compliant with the regulations. And so sometimes the first conversation I have with employers is with regards to the regulations, so that they have to understand their legal obligations. Okay, so getting to different paths to permanent residence status. So PR applications are generally speaking divided into three categories. So the humanitarian applications, the family class applications, and the economic class applications. So we deal with all three categories in my office, and we've been able to help many individuals and families through all of these different categories. Humanitarian is generally, I consider that kind of an application of last resort. Family class application, those have been prioritized by both the Liberal government and past governments. So, for example, if an applicant is in a spousal relationship with a permanent resident or a Canadian citizen, they often are not eligible to apply under the economic class or the humanitarian class. Sometimes that's an issue. I've had cases where an individual had an economic class application, and then they got married to a Canadian, and then their economic class application was refused, and they were extremely upset about it. And they did not understand that they were no longer eligible based on that spousal relationship. So currently, at least within the economic class, we're dealing with express entry, which is EE on the slide, and PNP. So in Manitoba, the MPNP program, which I believe was the first PNP in Canada. So we help individuals through both express entry and the MPNP program. I don't handle PNP applications for other provinces. I have a friend of mine in Saskatchewan, Chris Veman. So if someone's in Saskatchewan and needs help, I refer individuals to Chris. If someone's in Alberta, I refer individuals to Mark Holthe, and I have other friends across Canada. So if someone is in another province, then I will just refer that to a specialist in that province. Inadmissibility, this can be another kind of huge issue in immigration. Um, this was a big case that I handled, I think it was in 2018, dealing with the Warkentin family. And so in in that photo, you can see the daughter, Christy. So the blonde girl at the front there, she had a serious medical condition, and they were living in Dauphin at the time, and she had to be helicoptered to a hospital based on having a seizure, and the entire family was deemed to be medically inadmissible, and they were about to be removed from Canada. We were able to fight the removal order. We were able to work with the government, and we were able to get Section 38 changed. Um, and so, based on that case, in my view, probably thousands of people have been helped based on the changes to Section 38. But inadmissibility can be a major barrier. And one of the things that people sometimes don't understand is that if one family member is inadmissible in a permanent resident context, then all family members will be refused. None of the other family members can become permanent residents. So, in another case that I touched, it was involved a Chinese family. I did not represent them on any applications, but they came to me kind of at the end. So what happened in that case was they applied for permanent resident status. The father of the family had medical issues, and so the entire family was medically inadmissible, and they were all refused. Then afterwards, they submitted another application with a death certificate for the father. So the father was no longer included in the application. So the mother and the two children were approved. They came to Canada, and then after they landed in Canada, then the mother tried to sponsor the father, who came back to life. And that led to them in my office, because at that point, then of course the government uh, found that they had misrepresented, and that the death certificate, which was included in the mother and the children's application, was fraudulent. And so they came to my office to see what they could do in terms of staying in Canada. So dealing with express entry, within the economic class, express entry and the PNP programs are all points-based programs. And this was a pool from February of this year, just looking at the number of applicants within the pool and the range of scores of those applicants. So there are many candidates who are trying to come to Canada. Just from the numbers on the screen, you can see more than 100,000 people were in the pool in February of 2024. My guess is that number is increased. Many people are trying to come to Canada, and there's a very high demand, and I expect that there will continue to be a high demand for people trying to come. Within the PNPs, so from my point of view, the MPNP program is the best PNP in Canada. We have many people coming from other provinces trying to apply through the Manitoba program. The PNP has gone through many iterations, changing different calculations. And right now we have an NDP government, and the minister has been really focused on the close relative in Manitoba. So you can see at the top there that criteria that's kind of the pet project of the current minister. And so she is really trying to select new permanent residents who have close relatives in Manitoba in order to reunite those families. So in terms of citizenship, so typically when someone comes and they are in Manitoba, These are kind of the 5 steps that we take them through. So the first one is the expression of interest. Then there's the letter of advice to apply. Then finally, the nomination certificate. Then the PR application. And then finally, the citizenship application. So we love to guide our clients through all these steps. Sometimes they come to us after they have completed the first 2 steps and they get the nomination certificate. Sometimes they come to us just for the 5th step. That is completely, up to them. And so we're able to help them through whichever steps that they need to go through. So currently, in terms of immigration, I will say that we're dealing with long processing times. There are staffing issues at IRCC. The Case Processing Center in Edmonton, for example, has had significant staffing issues in terms of senior staff leaving. We've also seen unscheduled interviews. So, for example, a couple months ago, we had a client whose employer received an unscheduled interview, a call by an officer on a Sunday. The employer thought that it was a prank call. He did not believe that a government officer was working on a Sunday. I was able to contact a manager and to let the employer know that actually the officers are working on Sundays and that was not a prank call. So we were able to reschedule that interview and to get our client's application back on track. There is a high suspicion of fraud within the entire immigration system, and this has been going on since I started practicing in this area back in 2005 or 2006 when I started. Fraud has always been a big issue within immigration, but especially now where we're dealing with AI and we're dealing with highly sophisticated actors who are creating fake documents overseas. There's a lot of fraud within the immigration system. Then finally, and blacklisted agents. Again, I talked about that before. Good Samaritans. These cases are really sad because you have people who are trying to help, but in the end, they end up not helping. And then finally, this is something that we see quite a lot, is the intention of living permanently in Manitoba. So this is where an individual gets permanent resident status through the MPMP program. And then after they get PR, then they decide to move away. Let's say they go to Alberta. Well, that can lead to a procedural fairness letter, and that can lead to them losing their permanent resident status. So in terms of appeals, so in my firm, we also do litigation at the court. So we regularly do applications for leave and judicial review. We also do sponsorship appeals at the Immigration and Refugee Board. So spousal sponsorship appeals go to the Immigration Appeal Division. I personally love doing those appeals. Those are a lot of fun. Then we also do residency obligation appeals. So that is where someone has not complied with the 730-day rule. And those appeals also go to the IAD. And then we also deal with admissibility appeals, and those go to the Immigration Division. So those could be criminality, misrepresentation, or other types of inadmissibility. And just, I hope I'm not harping on this, but the number one problem in Canadian immigration is unfortunately just the rampant use of shady agents and immigration consultants who are charging lots and lots of money for poor service. And so these are just some headlines that I found online, talking about some immigration agents and some of the consequences. I'm guessing that most or many of the immigration consultants or many of the agents that are doing this work are not being caught, but these are some of the headlines from the news. So in terms of finding help, these are typically my points of advice. I generally just recommend that people find someone they can trust. I generally explain the difference between lawyers, consultants, and agents, et cetera, et cetera. and sometimes members of parliament can help. So if an individual has a simple case, and sometimes they do, sometimes it is simply they do have for a simple situation. And so in those situations, I would refer them to an MP's office. MPs, and again, these are federal MPs, as you know, MPs can provide very good help for individuals who have simple problems. And then finally, it is very important that the applicant does understand that when they are choosing a representative, that decision is extremely important because if the representative screws up, that ultimately the applicant is responsible. So this is my team. I I love working with my team. We have a lot of really good folks who work in my office, and we provide languages. We provide services in many different languages, and we try to be as 100% transparent with all of our services and fees. And there we go. It seems like I've wrapped up a bit early. It's only 11:35. I'm not sure if I've been getting any questions or if there are any questions, but I'm happy to field any questions. And so maybe at this point we can just kind of jump to the Q&A. So does anyone have any questions, or is there anything that anyone wants to talk about?
Nothing for me, but thanks for your presentation.
For sure. So I just see one comment from Douglas, very informative. Thank you very much. I know in immigration, often these cases are very individual. So I try my best to kind of cover things in general, provide some points in terms of stimulating the conversation. But if this was informative and there aren't any other comments, then just let me know and maybe we can finish early. Santana, did you get any questions before the presentation or before the session today? Was there did anyone raise any questions to you directly?
Nope, there were no questions. And I don't see any in the chat. So I guess we can leave it open for another 2 minutes if anyone does have any questions. And if not, we can end.
Sounds good.
Thank you so much. It was very informative.
Perfect. Well, as Rebecca said at the beginning of the presentation, we just got back from 3 weeks in Asia. And so I have a pile of work to do of just kind of getting things back on track. But I'm happy to do these presentations, and I'm happy to connect with people.
Well, thank you everybody so much for attending. As there's no questions, I think we can end here. Thank you, Alistair, so much. It was very informative and we all appreciate it.
Perfect.
Again, keep an eye out on the Law Society website for any further CLE that we may have.
Yes, and
Okay.
just to reiterate those thanks, thank you again, Alistair, for being here. Really appreciate it. And thanks everyone for attending.
Thanks, everyone.